Well, good afternoon, and thank you very much for tuning in to our webinar on personal injury costs 2022. I'm afraid I still haven't managed to fix my video camera as it insists on adding £5 to my face. And also, of course, it's very unforgiving if you're having a bad hair day, as I fear I'm having today. What we're going to talk about today are really four topics: solicitor-own client costs, deductions from damages, personal injury fixed costs, and clinical negligence fixed costs. And in terms of the format that we're going to adopt, I will be speaking for a few minutes on each topic, passing it over to Craig. And of course, you'll have questions. So if you send the questions to us as we're going along, we'll take a few minutes after we've given you our thoughts to see what we can say in response to them. So let's begin with solicitor-own client costs. And it may be that some of you tuned in last week to watch the seminal case of Belsner and Cam, which was taking place in the Court of Appeal. If so, you'll have noticed that it didn't get terribly far. I think by 4:15 on the first day, they'd managed to get to the second of the points which were engaged. And then, of course, on the second day, it was adjourned because the appeal had proved rather more complex than the division of the Court of Appeal had contemplated. And so it's now been relisted at some point in the summer for at least 2, possibly 3 more days of argument, and also in relation to the further skeletons being required as a result of the perceived complexities. But what is Belsner and Cam all about, and what is the significance that will prove to your practices? In essence, there are probably 4 points in Belsner and Cam which are going to prove of great significance to anyone who deals with costs in personal injury litigation, or indeed more widely. The first point is that it will involve a consideration of the construction of Section 74(3) of the County Court Act, which will, Solicitors Act, which will, of course, set out, in essence, whether there needs to be a written agreement permitting parties to obtain more than fixed costs in unlitigated cases, which is significant because some people have always thought that it was limited to litigated cases. It's also going to consider the interpretation of Rule 46.92 and the scope of a written agreement in order to contract out of Section 74(3). But of course, one of the issues that that's going to involve is consideration as to what extent the Law Society model CFA, or people who have derived their CFAs from that, are going to be compliant or not. And of course, there's a further point as to whether informed consent from the client in some shape or form is required under 4692 as it would be under 4693, the presumptions that govern when you can get back your solicitor-own client costs. The case is also undoubtedly going to open the lid on this issue of fiduciary duty and to what extent the courts are going to impose a fiduciary duty, if at all, on a solicitor negotiating for her own remuneration. And almost by a side wind, what has been raised as one of the arguments is the extent to which solicitors' duties about their remuneration might be governed by the Consumer Rights Act of 2015, with its duties of fairness and transparency. Well, the appeal is sort of launched, but not yet landed. And I think at this stage, what I can see unfolding in consequence of it is really this. The first point is that undoubtedly, solicitors in the aftermath of that decision are going to have to review their retainers across the board in order to see to what extent, if at all, they need to be amended consequent to the decision. The second big consequence, I think, is that the spotlight is very much now on cost budgeting and cost estimates and making sure that the client is not surprised with the bill when they get it, but it's been flagged up to them in advance, because that's going to be material to all sorts of points, including the issue of informed consent to deductions being made. And I think also the case will have ramifications on how solicitors draw their bills, because there's no prescribed form for a bill to your own client, but also what information needs to be on it, and of course how they're delivered. And so I think it's probably going to be the most significant cost case of the year, because although it's in the context of a personal injury case, the ramifications will probably apply to virtually every case. What do you think, Craig?
Well, I think if you pick up on the ramifications point, first of all, we're all going to hear from both yourself and me later in this about the extension of fixed recoverable costs. And the starting point of that debate for the recovery of remuneration is, of course, the model that is being adopted for the purposes of putting in place the remuneration is going to be that which was put forward effectively by Taylor-Rose and effectively by a defendant model. And so it's likely that the sum of, by way of costs that are going to be allowed as recoverable between the parties is going to be something of a disappointment to claimants and something of an approval by insurers or defendants. But the reality is likely to be that as a result of an ever-increasing fixed cost matrix, that solicitors who represent claimants are going to look to recover their loss of costs via their own client. And that is going to, I think, increase the number of challenges that are likely to be brought against solicitor-owned client bills. In other words, the notion that solicitor-client arguments are something which many senior solicitors would say that they've managed to avoid for their entirety of their career. I think that's not going to be the case for those practitioners who are currently in post and are coming into post. I think that's going to be a landscape in the future that is well trodden. And as a result of that, it seems to me that as sure as night follows day, if you are using the Law Society model CFA, you are going to have difficulties. I've firmly been of the opinion for probably a decade now, that the Law Society model CFA is not fit for purpose. And with each passing determination by either the masters at the senior court office or the determinations that are coming out of the district registry in the county courts in relation to solicitors' act assessments and deductions from clients, I'm becoming more and more aware that the idea that you can take this shortfall simply because you told the client that there would be a shortfall, it's just not going to fly, and you're going to have difficulties. I mean, for those of you who did tune in to the Belsner show, and you could get it on YouTube. It's still there if you search for it. It's worth a watch, if only to see the comedic value of members of the cost bar explaining to the Court of Appeal the distinction between contentious and non-contentious costs, and shocking them to the core by the notion that employment tribunals and the work therein is non-contentious. That seemed to cause something of a frisson of surprise. But there's an exchange between bar and bench during that matter, in which Ben Williams, QC, just gave us a throwaway line where there's a reference to the Law Society model CFA, and I think the words he uses, it simply hasn't kept pace with commercial realities. He almost sort of threw it under the bus. The reason I raise it, the reason I focus on it, is that, as Andrew's probably going to go through in a moment, sort of cases such as the one that was before Chief Master Gordon Saker, ST against ZY quite recently, and the comments therein about explanations as to shortfalls, explanations as to budgeting, explanations and informed consent to deductions in any shape and form. They're gaining traction. And this phrase, informed consent, whilst at the moment in Belsner it seems to have its genesis in notions of fiduciary duty, I think ultimately it'll morph into more of a sort of consumer rights type argument, simply on the basis that I think ultimately the idea that you can have a fiduciary obligation to somebody who is not yet a client, I just struggle with that as a sort of intellectual process. But it seems to me that there is an element there of consumer protection that will be addressed in one form or another, either in Belsner or matters that flow from Belsner. And that is going to say quite clearly, because it's the noise that's coming out of the district registry and the SCCO, that if you can't point to something where you've told your client what it is that's going to be deducted and why, then you're going to have some problems. And it doesn't matter whether those problems are as a result of a budgeted case where you've overspent the budget, but you don't appear to have ever got the express permission from the client, either in writing or otherwise, or even if it's a case where you are looking to recover from the client a shortfall, which is the difference between the hourly rates you've recovered party, and the hourly rates that you contended for in your conditional fee agreement or your retainer. It's not going to be enough to simply say there will be a shortfall. I suspect you're going to have to give some examples. And if in the case of hourly rates, and you're looking to take a shortfall from the costs recovered where the costs have been assessed or agreed with the defendants, I do rather suspect that you're going to have to be able to answer the simple question. And the question will be, if when you settled the costs party, you knew that you wouldn't get the hourly rate that you'd contended for in the retainer, why didn't you tell your client that when they signed the retainer? And I think that's going to be a problem question that needs to be addressed. So bringing those strands together, what am I focusing on? I'm focusing on the fact that one needs to keep a real close eye on the developments of Belsner and the cases that will offshoot from around it, and keep a close eye on how that affects the retainers that you have and whether or not those retainers are still fit for purpose. And if those retainers are based in large part upon the Law Society model, you might want to start to think about getting ahead of the curve now and start looking to change those retainers before you find yourself in the crosshairs of arguments between yourself and your former client. Of course, all of this can be avoided if you are able to run your business as a claimant firm simply upon the remuneration that those who make the rules are going to allow you to recover once they roll out the ever-growing raft of fixed costs. If you can make it pay for within those, then I suspect you're home and dry and can probably have your retainer on the back of a proverbial fag packet. But if you want to take anything from the client, you're going to have to get more ingenious, more creative, but more importantly, have a retainer that is drafted, that is lawful, clear, transparent, and genuinely communicates the reasons for and the types of sums that you are going to deduct from the damages.
Brilliant. And I think the only other point I would add to this first topic is there's a real policy issue for the Court of Appeal to grapple with, whether they do it expressly or just implicitly through their decision, which is to what extent should issues about fees and overcharging be dealt with by the courts with a relatively light touch, noting that the client can go to the Ombudsman, can complain to the SRA, whatever means of redress they choose, or to what extent do they make the SCCO and the district registries consumer champions dealing with huge volumes of solicitor-own client disputes? So we'll wait and see. But that brings us fairly seamlessly into the issue of questions, because we've only had two so far. The first one being, are there going to be any notes? And the answer is probably yes. And the other one is, are you doing a fixed price for drafting appropriate retainers that take from client? Asking for a friend, to which the answer is, you don't need to speak to me, you need to speak to McClar. So if we move on, do keep the questions coming, and we'll move on to the next topic, which is deductions and damages. If you consider the halcyon days before 2013, because unbelievably or not, Craig and I were both in practice before 2013. The situation was that clients very rarely had to pay a deduction from their damages. By and large, because solicitors recovered additional liabilities, including success fees, as well as ATE, there was no need to charge the client. When Jackson bit on the 1st of April 2013, that practice had to change. And indeed, it was contemplated in the Jackson report that clients would be paying money from their damages for success fees. And that was actually quite good, because it meant that they had skin in the game, and it meant that they would shop around for a market beating rate, comparing solicitors against solicitors. Leaving aside the extent to whether that happened, as we've already discussed, the fact that you take deductions from damages has effectively fueled the solicitor-own client cost war, which is now raging and has raged for at least 3 years. One particular subsection of deductions has proved to be particularly controversial in recent months. That concerns deductions from children or deductions from protected parties, and in particular, the extent to which the court will approve those, because as you'll appreciate, where either of those categories of claimant are concerned, the court has a role in approval. That led, I think, to what I would describe as the start or the firing shot in a quiet revolution in the SCCO, the publication of a practice note in December dealing with the approach that the court will take. And in essence, what the court was concerned to note was that although Part 21 and Practice Direction 21 are in play, not to forget Part 46, which provides that in any case where there is a child or protected party, unless the solicitor is effectively waiving their claim for costs, there must be a detailed assessment. That led to 2 decisions in quick succession, which illustrate the difficulties that the approach being taken by the SCCO, which will undoubtedly bleed out to the district registries and county court, are posing. Because the first particular point is that in a case called BCX and DTA, a fairly substantial case, the defendant and the claimant agreed to accept £330,000 towards the claimant's costs on an inter partes basis. But because there were still substantial deductions being sought from damages over and above what had been recovered from the other side, the case had to go for detailed assessment, and it ended up before Master Brown on a provisional assessment. Now, one of the consequences of this is that you cannot regard the settlement reached between the claimant and defendant as an irreducible minimum, a floor below which the court assessing the bill on a solicitor-own client basis will go. It doesn't work like that. And one of the consequences was that after the dust had settled on the provisional assessment, there was a shortfall between what had been assessed and what had actually been recovered of about, well, just under £30,000. And the consequence of which, of course, is that being client money, it may well have to be returned to the client in due course. However, that case, as I say, was at a provisional stage, and I have no doubt whatsoever that it will go forward to a review where the picture may change. In relation to another case, this one dealt with by Master Gordon Saker, the senior cost judge, called ST and ZY. This was another case where a significant bill had reached an agreement on an inter partes phase, but because it involved children rather than a patient this time, it had to go forward to assessment. And what the master did was really significant in 2 ways. The first was that he applied the presumptions which apply to solicitor-own client act assessments, including the presumption which relates to unusual costs. If you incur costs which are unusual in amount or nature, then you have to tell the client that they're unusual and might not be recovered from the other side. And he focused upon the fact that the client didn't seem to have been engaged in the costs budgeting exercise. The consequence of that is that when the costs on the cost budgeting, cost management exercise were cut downwards, as they usually are, because there had been no apparent attempt to engage the client in saying, well, you know, we've lost so much on the budgeting exercise, but we still need to expend these costs. Are you happy that we go about, even though you won't recover them and they will be payable out of damages, the master disallowed a very large amount of costs on the basis that they were the excess over the cost budget, which had not then subsequently been the subject of specific instructions by the client to incur going forward. Now, what this means, I think, going forward is that there's effectively going to be a much more rigorous approach taken to approval of deductions from damages in respect of clients' money when you're dealing with these two particular categorizations. I will go further and say that there has certainly been in some of the older district judges in the county courts an evident distaste for making deductions from damages, particularly in the cases involving children, despite what the Jackson report was expressly contemplating would be the case. But I think what it means is that you have to be very careful going forward. It also means, I think, that on the client care side, you have to demonstrate, if there are likely to be deductions, that the client does approve the amount of those deductions. And in effect, it involves perhaps more element of engagement with the client on cost matters that might hitherto have been thought to be matters which were really for the lawyers to sort out between themselves. But what do you think, Craig?
Starting from the defendant's perspective, one of the matters that came into my mind when I read the provisional decision of Master Brown in BCX, and I appreciate that that's going to go further. It's going to be the subject of a final determination, and potentially, of course, it could go further and on to an appeal. But just parking where it might go and just dealing with the subject matter of what was determined, you make the point that ultimately, because of the approach taken by Master Brown to the assessment of the solicitor's file, the outcome was that on a preliminary basis, the master assessed the solicitor's bill in a sum that was in fact less than that which had been agreed to be received from the defendants. And of course, that throws up a rather interesting dilemma, almost a sort of a planning dilemma for how you run your business. If you are a claimant and you are within those areas of personal injury or clinical negligence work that are likely to become the subject of fixed fixed costs, then it seems to me inevitable, unless you commoditize or mechanize the process. And I have to say, I find it conceptually difficult to see how you can commoditize or mechanize significant personal injury work or significant clinical negligence work without failing in your professional duties as a solicitor. It just seems to me, I can't see how you would do it, but I'm sure someone out there with a greater mind than mine might be able to work it out. But it just strikes me that if you try to, you'll run the risk of being negligent. And so I expect that those that stay within the industry will be or ought to be, those people with a high skill set doing specialist work, but they need properly remunerating. And that remuneration is going to have to come out of their clients' damages. In which case, the issue and the approach of the district registries and the masters at the SECO is going to come into focus. And it might be right that the focus has been driven by perhaps those cases from one or two firms that are taking shortfall of damages in cases where the claimant is a child or a protected party, and so the court is compelled by dint of the rules to assess. But it's going to continue into, generally, it seems to me, the wider cohort of firms, because unless you commoditize it, unless you mechanize it, it seems to be inevitable that in fixed recoverable costs cases, you are going to incur, if you're going to do your job properly, more costs than you are going to recover party, in which case you are going to come into conflict with your own client potentially. Now, we've spoken about the retainers and the need for those retainers to be capable of supporting the contractual bases of that deduction. But you also then got to get over the, as you quite rightly point out, Andrew, the natural dislike, distrust, distaste for the deduction of damages from protected parties. Now, it may well be that the district registrar in the Senior Court Costs Office, that whether it's subliminal or whether it's subconscious view of that, it just evaporates because it becomes a reality of the commercial world in which this sort of work is done. But nonetheless, it does throw up a real issue about explanation and understanding and the context of when that information is going to be given, and the behaviours that are likely to be driven by that is I can well see defendants at the end of a case saying, well, this is all terribly interesting and we'll agree a figure on the bill of X, but we only agree it on a preliminary basis, subject to there being a solicitor-owned client assessment if one is called for. And I do wonder to what extent some kind of informed consent extends to the notion of having to explain to the client ex post facto in some form of yet uncharted detail that they ought to be going for this kind of work, this kind of assessment, because it is likely that therefore any deduction from their damages may be wiped out. The point I'm struggling, I suppose, to make is that there's the law of unintended consequences here. And there's a time when we're told that courts' resources are scarce. There appears to be the brewing of a perfect storm in which there is almost an encouragement for clients to challenge any shortfall at the same time that it seems to me the business of law, of personal injury law, of clinical negligence law, is being inevitably forced to look to their own clients for some form of contribution to their costs. And those that make the rules, those that adjudicate upon the rules, and those of us as lawyers need to be careful that what we are not doing is quietly walking into a storm of contentious litigation with our own clients that cannot, in fact, be headed off unless there's a root and branch understanding of who's doing what, for what, and who's paying for that. And I'll end on this point by, in passing reference, noting that the whole sort of concept of the Simmons and Castle uplift seems to have evaporated from the thinking. There was supposed to be some form of extra pot, this extra so-called 10%, that was of itself supposed to somehow flow to solicitors as recompense. And in those circumstances, it seems to me that there at least ought to be a recognition that there was a Simmons and Castle uplift, that there is a statutory regime about success fee deductions that's already in place. And there therefore ought to at least be an understanding that there is not only an inevitability about shortfall charging, but there is also already in place a respectability about that charging. And that ought to be the starting point. So leaving aside notions of whether your retainer allows you to, leaving aside notions that I think we can all accept of consumer need to ensure the client is fully informed, I think that has to be built on an understanding that there is an inevitability about this charging and a respectability about it brought by the changes that led us to where we are in civil costs. But I do and am intrigued by the notion of now defendants saying, "Oh, well, I'm not so sure whether I want to settle this. I might be being too generous." Anyway, back to you, Andrew.
Thanks, Craig. We've got a few more questions in. The first one is, does Sunny the dog have any input? And I'm afraid that Sunny tells me she's concentrating on her personal injury practice at the moment and doesn't want to soil her paws with costs matters. So that's that answer. Another one is the practice note on deductions accessible? Yes, it is. It's in the update to the White Book and probably on a judicial website somewhere. And then we've got a few more questions here. Craig, there's one I think directed to you in the chat box, where it's talking about one of the points you've just made. Do you want to have a look at that?
Well, I would if I could make this thing open. Can you
Right.
read it out, Andrew?
Yeah. Returning to the point made by Craig Ralph on the potential necessity to inform the claimant at the outset in the CFA the constituents of its cost likely to be unrecoverable from the paying party, would it be wise for there to be a section within the CFA containing an exhaustive list of these suggested constituents, such as hourly rates, disbursements, etc., or would it be enough to simply state something along the lines of any cost not recovered from the other side may be taken from damages?
Two responses. Firstly, congratulations to the person who managed to type out such a lengthy and detailed question whilst I was speaking. That shows a particularly adept and agile mind. So well done, that person. I think the reality is that you're being slightly mischievous in that you've set up two sort of ends of the spectrum there. What you've said is it either the most detailed diatribe of an almost algorithmic table, or is it enough to simply say, we is going to take some monies out of your damages? Well, the truth is it's somewhere in between, isn't it? The reality is that, as you point out, there are constituent parts of any deduction. And going back to Belsner and the Court of Appeals debate between bar and bench, I think the Master of the Rolls rather surprisingly, but I'm assuming he was simply being glib, when he said that he didn't expect that that people were able to understand the documents of conditional fee agreements when they're put to them. Well, if that's right, leaving aside the fact we appear now to have a new strand of Lestrange and Gracop, so it's no longer duress, misrepresentation, or fraud, we now seem to have being stupid or being not that clever as being a reason for not being held to that which you sign. The reality of the matter is that you can bombard people, I think, with too much information. But I don't think that's the problem here. I think the problem that we're having is in the real world, not that we are bombarding people with too much information. It's quite the contraire. It's that we're not giving them any information that's actually accessible in a meaningful way. Simply saying to you, there will be a shortfall from your damages is unhelpful. Equally, it's unhelpful to say to somebody, we'll only take X percentage of your damages as a maximum. And the reason for that is that without more, in monetary terms, it's perhaps unhelpful. The real answer to that is this. What you do is you explain what each of the constituent elements are, hourly rates. The guideline hourly rates are X. Our rates are so many pounds per hour over it. We will therefore look to you for that sum. If you're contending for a success fee on the hourly rate aggregate, you can say that's wholly irrecoverable from the other side, except in certain circumstances, and therefore that will equate to X. And you can then deal with ATE premiums or anything of that nature. You also, I think, need to say to the client in very clear words that if this is a case which is subject to cost management and court-ordered budgeting, that any costs that are incurred over and above the budget will likely be costs that will fall to be paid for by the client out of their damages in addition, albeit it will be made up of the aggregate of the hourly rates. I think you've got to give examples. Personally, if you don't, I would put that into a separate, a small bundle that can be given to a client, so they've got it always to refer to, and it can then be standardized across your client care paperwork. But of course, the other way you can do it is to do that which was discussed in HH and HH Law and Herbert, which is that what you say to somebody is that no matter what happens, we will guarantee that you will not have deducted from your damages any more than X, or you will always recover X percentage of your damages. They've been told what it is. But I still think you would be required to have explained to the client what the deduction sum that remains was made up of. Otherwise, for the reasons that have already been outlined, they would be irrecoverable because the client hadn't given any form of informed consent to those constituent elements. So the short point is, it's neither side of the point you hypothesized. It's somewhere in the middle. It requires of some explanation, but solicitors are clever people. I'm sure they could quite easily and readily draw up a table and an explanation. But what I don't think is going to sustain going forward is simply notions of there will be shortfalls, you will pay them. And I think you will be very quickly exposed, if that is your business model, in circumstances when there is a shortfall brought about because of a party-party assessment of costs, and the significance of the shortfall and the success fee thereon is an aggregate of the difference between the hourly rates you had in your retainer and the hourly rates you knew you were likely to recover on a party-party assessment. If you're going to have a business model like that, that's all well and good, but make sure the client knows it from the go-get. Back to you, Andrew.
Thanks, Craig. Just two quick points. One point said, is it good practice for the client to be asked to agree the budget and informed about it? And the answer has to be yes.
Well, that was part of the original version of the budget certification. Correct me if I'm wrong, and my mind might have let me down, but wasn't the original version of the certificate the client? It was envisaged in the original draft that it would be the client who would sign the budget.
You know, you're sparking my memory as to whether that might have been the pilot.
Yeah, I'm sure I've seen it. I mean, somebody out there will I'm sure recall it, but that was, so it seems to me that the answer is the gold standard, and the gold standard should always be yes.
Yeah, and I think where people come into problems is that because the budget these days is signed by the solicitor, they assume it's nothing to do with the client, but of course it is, for the reasons we've discussed. The questions are starting to explode forth, but we'd better move on because we're now at 4:38. So let's talk about PI fixed costs. Now, the headline date is October 2022 for the fixed costs to be brought in, not only, of course, for personal injury, but for all sorts of work up to a limit of £100,000. And in particular, what we now call fast track cases will be split into bands 1, 2, 3, and 4, up to £25,000. And then for what will be called fast track intermediate cases, that is 25,000 to 100,000, with a trial of up to 3 days, those are to be put into a further set of bands 1, 2, 3, and 4. Where it starts to get complicated is that NIHL will have its own set of bands. But in practical terms, band 1 will be cases which are quantum only disputes. Bands 2 and 3, issues where the issues are liability and quantum of varying levels of complexity. And band 4 is reserved for cases where there are serious issues of breach of duty, causation, and quantum. To explain how it works, in effect, there'll be a huge table with all the various bands divided by stages in an action. And you're meant to be able to just look along the table to see how much your case settled for, the stage it's settled for, and then work out what your fixed costs are. To give you an example of some figures, if your case is a quantum only dispute in band 1, if it goes all the way to trial and you get a judgment for £30,000, your fixed costs will be £19,150. If it goes to trial and the judgment is for £50,000, your fixed costs will be £22,150. And if you go all the way to a 3-day trial with judgment for £100,000, so that's the upper limit, then the fixed costs will be £29,650, to which will be added reasonable disbursements, but not counsel's fees, save and insofar as those are carved out as exceptions for band 4 cases. And VAT, of course, on top. Moreover, there are some further carve-outs in that mesothelioma and the asbestos cases won't be subject to fixed costs. Clinical negligence, as we'll find out in a few moments, has its own regime. Actions against the police and child sexual abuse cases won't be covered either. As I say, council's fees are not ring-fenced, save in the upper parts of the table. And also there's going to be a fairly significant modification to Part 36 in that the entitlement to indemnity costs will be lost. But if you beat your own claimant's Part 36 offer at trial, there'll be a 35% uplift on the fixed costs. So what are the conclusions that I draw really from this? The first point is that this is going to be a real game changer, because not only will it alter dramatically the ambit of cases that are subject to fixed costs, I've no doubt in time this will prove to be a model for further expansion. The second point is that you're going to have to think very carefully indeed, by looking at the table when it ultimately comes forward, how and when you pitch your Part 36 offers, and how you ensure that when you go to trial, you get the free money effectively that a 35% uplift would represent. And the third point is, of course, this. Although this will apply to personal injury claimants, and the idea is, of course, that it reduces the overall cost of litigation, it's not coupled with procedural reforms to any great extent, which alter the way that these cases are dealt with now. So there's lots of scope here for tactical manoeuvring or causing people to spend money doing things where the defendant's downside is limited. And depending upon which side of the fence you're practicing in, that's either a bad idea or a very interesting business opportunity. But over to yourself, Craig.
I'm going to pick up, Andrew, on this idea of really tactical approaches to it. I think we're all big enough to smile wryly when we're confronted with a document produced by an organ of the state that has the laudable aims of trying to ensure that matters are reasonable, proportionate, streamlined, and reduce the impact upon the court service. We've always had in this country an adversarial system. We don't have an interrogatory system whereby the parties' positions are neutrally evaluated. The court system is adversarial. The people who work within the industry are adversarial by and large. The reality is that once you have fixed costs, there will be two stages of prominence. The first will be those who represent claimants looking for ways in which they can increase the amount of costs that they can recover, either by jockeying for position into different bands so as to increase the amount of fixed costs that are recovered. And at the same time, you can see that defendants are going to look to behaviours that they can adopt in order to encourage claimants to settle the claims before they move through the stages and at an earlier stage. And so there's going to be some jockeying about all of that. And of course, the devil will be in the detail as to what sanctions, if any, of merit are going to be applied. It's clear from the initial documentation that was produced by the ministry that deliberate actions and the bringing of applications to move yourself from one section into another section could be considered as being something that is sanctioned as an adverse behaviour. But all of that seems to me to be something that will create of itself a real elongating of the bedding in process. I mean, we're now in 2022. We've had fixed recoverable costs in Part 45 now for over a decade and beyond. And we're still having arguments as to escaping the fixed cost matrix in order to secure a better remuneration. And you've also got behavioural approaches being taken by defendants to seek to encourage early settlement. By way of an example, I can't be the only practitioner who's noticed that the frequency by which the words fundamental dishonesty are uttered in one shape or form seem to be on the increase. Those are tactical determinations. Fixed recoverable costs is predicated at its core on everybody playing to the same set of rules. And the devil is going to be in the detail here as to how, when, and what the ramifications are for those who use tactics either to jockey for a greater level of remuneration or jockey to settle or push a claimant into settling early for a figure that is perhaps lower than would have been accepted with a well-resourced claimant in pre-FRC days. So the devil's going to be in the detail, I think, without a shadow of a doubt. So we'll wait to see the rules and practice directions that underpin all of this. But it seems to me that if I was to be picking sides for where the wind is blowing, it's blowing into the sails of defendants rather than blowing into the sails of claimants. The clear intention here is to bring down the cost of litigation that is being driven by these sorts of cases. That, it seems to me, is only going to occur, again, if you commoditize or mechanize. And I'm struggling to see how that's going to be capable of being properly done. So we're still a long way to go with this. The deadline, of course, is later on this year. I haven't seen much by way of rules that deal with the behaviors that will be driven. And I think that's where the battleground is going to be drawn. Bringing the strands together, I think we are going to live through interesting times.
Yes, indeed. We've had a couple of questions, but I'm only going to deal with a couple of them briefly because we've in the last 10 minutes now, we need to deal with Clin Neg. The first point is a question, the amounts seem quite low. Are there any plans to look at raising these amounts in PI? Well, they will probably go up by inflation in the sense that the figures I've given you were set a few years ago, so they'll probably be topped up a little bit, but they represent, I think, pretty much the final version. The second point was asked was, well, does this apply to not only deafness, but vibration white finger and arm vibration syndrome? And the answer is that's a very interesting point because there's plainly going to be a set of fixed costs for NIHL. I'm not aware that HAVS is lumped in with that, but there is a further exception which isn't defined, which is called complex PI. Now, whether, if you like, the other types of industrial disease are going to fall into that remains an interesting question. But at the moment, of course, what we're dealing here with is the policy papers. Nobody has seen any draft rules or practice directions which will spell out the detail. So let's move on in the last 10 minutes to the issue of clinical negligence fixed costs. The first point to note is this process isn't as far along as what I'd call the mainstream fixed cost proposals. And the reason is because it's still out for a consultation at the moment. So theoretically, at least, once you've logged off here, you can draft your response to the consultation, secure in the knowledge that the government will look at it in good faith and take it into account, or not, as the case may be. But what it proposes really is a set of proposals that focus on the pre-action stage. And in effect, what they want to do is divide clinical negligence cases of up to £25,000 in value into two types, which they call standard or light. They actually call it the standard track or the light track. But that's confusing because we're dealing with this at the pre-issue stage. And the notion is that you get all your evidence together, you provide it to the defendant in a process of sequential exchange. They come back to you with a reply or their own evidence or whatever. If you can't then agree, then the matter will go forward after a stock take to an early neutral evaluation. The early neutral evaluation, interestingly, is to be carried out by a barrister from what is an agreed panel. And they produce something which is, if you like, a non-binding opinion or determination as to where the case may end up. And then the parties are meant to look at this and then think about whether that answers the point so they can settle the case, or whether in fact they need to go forward for whatever reason to litigation. This process is going to be subject to fixed costs, and it's going to be subject to time limits. And the idea is to shave or close down the period of time currently extant between putting in a letter of claim and the case ultimately being resolved. The government has assumed, possibly rightly, that time is money, and the longer a case goes on, the greater the cost that will be incurred. The question as to why these cases have been taking longer to determine is left cloudy and unclear in the consultation paper. But if we take, for example, a case which is on the standard process, which goes through all the steps of getting together up to 2 expert reports on liability or causation, plus possibly a condition and prognosis report, all the way through an early neutral evaluation, then the costs that a solicitor will recover are £5,500 plus 20% of the damages for the stage before the early neutral evaluation, and then a further 500 quid on top. So if you do the maths, what that means is that for a case which settles after the early neutral evaluation, the solicitor's profit costs, or fixed costs at least, will be £11,000 plus VAT, plus of course the reasonable disbursements of the experts and such like on top. So very interesting procedural reform, though it doesn't touch the court process, but it doesn't touch the substantive law. Bolam test still applies. You still need to establish fault on the basis of expert evidence. You still need to do everything that's involved in that. And included within these costs is money for effectively getting all the claimant's medical evidence, medical records, collating them, paginating them, and putting them forward on an agreed bundle basis for the use not only by the experts, but also by the defendant. So what I foresee rolling from this is that when you're dealing with clin neg, it's not quite the same as just another species of PI, because it's not only damages, there's the reputations of the clinicians and the hospitals involved. So that sort of takes it out of it. The second point is that what we're seeing here is, I think, what I would describe as a dramatic reduction in likely recoverable fees, which inevitably will have an impact upon solicitors acting in this marketplace. And that in turn leads the question as to whether, in fact, this will facilitate access to justice or impede it. But what would you say, Craig?
Well, first of all, I think I'd urge those who are stakeholders in all of this, those who are practitioners in this area of work, to read the document and respond to it. I appreciate that with a busy practice, there is perhaps a natural desire to say, well, somebody else will do this. But it's there, it's out for consultation. It's on the government website. It's headed Fixed Recoverable Costs and Lower Value Clinical Negligence Claims, a consultation. It's published in January 2022. It runs to about 80 pages. A lot of it is certainly the early part of it through to really the first 20, 25 pages of it are simply setting out the background matrix upon which these changes are predicated. It's all about the Jackson reforms and the rationale for reform and why this is seen as being a necessary process. But we then move into the meat of it, which is what those processes will be. And that picks up in really from pages 26 onwards. And it's worth reading that, understanding what is being proposed here, how and why it's being streamlined and what the costs are going to be. And the reason I say it's worth looking at is it seems to me that it will inform on a macro level the approach that firms will take as to whether or not they stay in this sort of work. And if they are going to stay in this sort of work, how they are going to maintain profits within that area of work. In other words, the starting point really for those of you when you read this is to look at what is being intended by this process. so that whilst you can object, seek to persuade, put forward evidence as to why this should be changed, tweaked, abandoned even, the reality is, it seems to me, that if you read from start to page 25, you'll be left in no doubt, this train, it's coming. And the most you might be going to do is to decide which sandwiches are in the buffet car. And therefore, you need to start to look at, are we going to stay in this work? And if we are, then you need to look at pages 39 onwards as to what is being proposed as the system, and how you are going to function within that system from a mechanical point of view. In other words, this is a streamlined system. Can you, in fact, ensure that you meet that sort of streamlined deadline? And can you do it in a way that is profitable? And again, then we're back to the earlier point. If you look at that and say, yes, we can do it, but if we're going to discharge our professional obligations, remain on the right side of a negligence suit, then we're going to have to bring this level of resources to bear. In which case, then there's going to be the shortfall. We're going to have to look from claims damages. Okay, let's all go back to our Rule 2, Rule 15 letters and our CFAs, and let's see if we can make it work. But I do say it's worth reading. It's worth reading for those of you who intend to seek to persuade, change the minds of those that are going to put these rules and procedures into place. But it is predominantly, it seems to me, something that needs reading so that you can understand the train that is coming down the track, and so you can be preemptive about how you maintain, direct on a macro level the firm in order to ensure that you meet the challenges that are undoubtedly coming. And at the same time, it seems to me that once one reads this document, whether you're claimant or defendant, it will also give you a seed corn of the behaviours that are likely to be adopted in order to either push down the costs that are paid out or increase the costs that can be recovered. And I know that we are speaking, Andrew and I, to a sophisticated audience out there. And so it's not just me in my little cynical world that has these thoughts. And so starting point is go and get this, download it, read it, think about it, pin it to the wall and discuss it with your colleagues, because it's coming and its effect is, to my mind, more significant than the regimes of fixed costs that have gone before, because it is dealing with a much more complex litigation area that doesn't lend itself so readily to being commoditized. Right, Andrew, back to you. Let's see if we can do some questions.
Yeah, there's a question for you, Craig, which may in fact be a request for free advice, but I'll pose it to you and see if you can answer it or not.
No, it won't be, Andrew, because it would come with the immortal words, the brief will come to you if it goes any further. So unless the question has those words in it, it's not a request for free advice.
Oh, that's all right then. It says, if a defendant pleads potential fundamental dishonesty in its defence, in your experience, does that in itself trigger exceptional circumstances under 45.29J in a fixed cost?
No, because nothing triggers it in a bright line. I mean, that's as simple as that. We all know it's a high hurdle. But it seems to me that it is. Can I make this point? If you are going to look to recover more costs in a fixed regime by the exceptional circumstances, then it seems to me you have to construct some form of argument that is evidentially based. I appreciate there is authority. There's a significant debate between bar and bench in which this very issue was debated with Alex Hutton. And the decision was that, well, it isn't really a causative link. But it seems to me that the primary point, which is getting over the high hurdle, requires you to show what was done. And the joy of an electronic bill is that you can interrogate it by words. And so if you are confronted with some reference to fundamental dishonesty as a claimant representative, make sure that the attendance note the telephone note, uses the word somewhere in it of fundamental dishonesty. And when you instruct your cost lawyer to draw and draft the bill, make sure that when they enter it into the narrative within the item cell, that they use those words, fundamental dishonesty. Why? Because at least then when you go in front of a judge, you can invite the judge to do a search by the words fundamental dishonesty, and you can show the amount of extra cost that was incurred as a result of that. And you can then argue that exceptional means nothing more than out of the norm. And this is clearly work that is out of the norm, because it was never envisaged that such matters would be the ordinary run-of-the-mill fodder of this kind of work, which by its nature appears to be commoditized or expecting of some form of commoditization. That is my view and my take on practically dealing with it. But the bright line question, which is, if they say it, is it exceptional circs? Answer, no, because there's no such bright line exception. If there was, then of course it would have been set out within the rules of the practice direction.
I think the position has been reached that despite early indications that, for example, alleging fraud and then losing on it would be an exceptional circumstance case. And I'm going back to Cader and Isha, probably one of the
Kersey and Tarfeld and all that.
Yeah.
Sort of,
The notion has taken root amongst the county court judiciary that exceptional circumstances are resolved for God and his angels. And, mere mortals don't deserve such things. But maybe that's a cynical note to end on. Because we're now, ladies and gentlemen, at 5:02. It's been great to speak to you again. We'll have other seminars coming up later in the year, and we hope you'll tune in to see our colleagues when they deliver them. But I think from us now, it's over and out.
Thank you all. Thanks for joining in, and goodbye.
Cheerio.